Hey guys, welcome to another installment of Business Law. I want to kind of finish up corporations today, move on to LLCs. I will get in your emails to you guys in the next day the extra credit assignment, which will be due the date of the final. I'm not sure what the date of the final is. I'll check on that and send out an email as soon as I can. Like I said, I want to just finish up some stuff about corporations and talk about LLCs, limited liability companies. We might have a little bit of time to go over crimes against business, and this will probably be the next to last video lecture, maybe one or two more after that. Then we'll concentrate on preparing for the final and getting our extra credit assignments done. I'll try and get that extra credit assignment out to you guys in an email today. So finishing up corporations. Again, remember the two most important things we've talked about with regard to corporations. The corporation being a separate legal entity and the limited liability of the owners of a corporation. Just to touch base a little bit more on how a corporation is a separate legal entity. Corporations have constitutional rights just like individuals do. So a corporation has a right under the Fourth Amendment, for example, to be free from illegal searches and seizures. So in other words, a corporation, if you want to, if the police or other law enforcement agencies want to search the headquarters of a corporation or go through their email or their records or anything like that, they have to have a warrant. Absent exigent circumstances, which we won't get into, they have to have a warrant to do that, even though the records, for example, are owned and possessed by the corporation. The corporation, under those circumstances, is treated just like an individual person. A corporation has a First Amendment right to free speech, and typically you see those rights exercised in the form of advertising, commercials. Remember, the First Amendment protects commercial speech just like political speech and other forms of speech. And recently, well, over the last 20 years or so, our Supreme Court has strengthened the protections for commercial speech. So obviously that First Amendment right of a corporation to engage in speech, and in particular commercial speech, is extremely important. And you see some First Amendment cases dealing with restrictions that government has put on, typically state governments, has put on advertising. And a number of those challenges to those types of laws have been successfully litigated before the Supreme Court. And the Supreme Court has reinforced the idea that commercial speech is protected under the First Amendment, whether it's a corporation making that speech or an individual making that speech. So again, I just can't stress enough, and I know I sound like a broken record, but a corporation is a person, and the owners of the corporation have limited liability. Now, I want to talk for just a minute about a couple of the corollaries when we talk about corporations. The first is when we talk about a close corporation. Remember, we went through the four characteristics of a close corporation in the last lecture. The shareholders all know each other or are family. There's no market for shares. There's restrictions on the sale of shares. Gosh, now I forget all the four characteristics. You can go back to the last lecture. I don't have them in front of me. Know each other or are related, small number of shareholders, restrictions on the sale of shares, no market for shares. In a close corporation, the shareholders owe each other and the corporation what's called the fiduciary duty. Also, partners in a partnership owe each other a fiduciary duty. And so I want you guys to understand on some level exactly what a fiduciary duty is. A fiduciary duty is the utmost duty of good faith and fair dealing. If you owe someone a fiduciary duty, if you owe a partnership, a close corporation, a fiduciary duty, that means that you have to subordinate your own personal interests for that of the corporation or the partnership. Okay? You have to put the corporation first. You have to put the partnership first, or you breach that fiduciary duty. And if you breach that fiduciary duty, you can be sued and made to pay damages. So what exactly does that mean? Let me try and give you an example of a fiduciary duty. So I'm a partner in a law firm, and we have a partnership agreement that requires us to split our profits, that split all the profits of the partnership equally. And one day I'm sitting in my office, and 15 people who have been involved in a horrible bus accident come in and want to hire me to represent all 15 of them in this bus accident. It's a great case. There's plenty of insurance available. This is a one-of-a-time case for me. I'm going to be able to retire after I successfully litigate this case. And so I start thinking, man, I don't want to share all this money with my partners. Or if it was a situation or a close corporation, the other owners of the close corporation. And so I come up with a plan to leave the partnership, but to take this case with me so I can keep all the money for myself. I'm going to get into trouble if I do that, because at the time that case walks in, I'm a partner in a partnership, and I owe my partners a fiduciary duty, and that requires me, again, to subordinate my own interests to that of the partnership. So if I breach that fiduciary duty, if I put my own personal interests ahead of the interests of the partnership, then I can be sued by my partners for breaching that fiduciary duty. Again, a fiduciary duty, the utmost duty of good faith and fair dealing. You've got to put the partnership or the corporation ahead of your own interests. And that's not necessarily always easy to do, but it is vital to a successful partnership or a successful close corporation. You can think about the implications of if every partner could just run off and do whatever was best for them, regardless of the consequences to the partnership. It would have a devastating effect on the partnership and or a close corporation. So remember the definition and the workings of that fiduciary duty. There's all sorts of other examples of where a fiduciary duty exists. We're not going to get into those, but if you're curious, you can check out those for yourselves. All right. The next thing I want to talk about is, again, we spent a lot of time talking about how the owners of a corporation have limited liability. They're not liable for the debts and responsibilities of the corporation. Even if they're the sole shareholder, even if there's one shareholder, two shareholders, their personal assets are not on the line for the debts, obligations, judgments against the corporation. Unless you fail to treat that corporation as a separate legal entity. There is a very rare situation where the owners of a corporation can lose their limited liability. And when somebody goes after the owners of a corporation, claiming that they should personally be liable for the debts and obligations of the corporation, we call that piercing the corporate veil. Okay, I'll say it again. Pierce the corporate veil. And that's a situation where, say, somebody sued the corporation. They think that grounds exist to get around the limited liability, and so they attempt to pierce the corporate veil. Now, what are the situations where you can pierce the corporate veil? If you were to look at the case or common law in any state, but in particular West Virginia, you would see that courts have laid out dozens of factors that courts should consider in deciding whether or not to pierce the corporate veil. And again, it's very rare that this occurs, and only kind of under extreme circumstances. But it is a possibility that you guys need to be made aware of. There really are 2 or 3 main factors, along with, again, dozens of other smaller factors, that courts will consider when deciding whether or not to pierce the corporate veil. The first 2, which are kind of related, are basically if the owners of the corporation do not treat the corporation as a separate legal entity, they risk losing their limited liability. Now, what are some of the things that you can do that will show a court or be evidence of the fact that you haven't treated your corporation as a separate legal entity? And the number one thing under that is a commingling of assets. In other words, you commingle your own personal assets with those of the corporation. You don't treat the corporation like a separate legal person because you wouldn't commingle your assets with anybody else. With somebody you knew or a stranger or anybody else, and you can't do it with regard to a corporation either if you wish to keep your limited liability. So, for example, let's say I'm the sole shareholder of a corporation. Again, I'm the only owner. I own 100% of the shares. But what I do is I commingle assets, and how I do that is I don't keep a separate bank account for the corporation. Or even if I do, the corporation pays my personal bills out of the corporate accounts. So the corporation's paying my power bill, paying my mortgage. I treat it as if it were just an extension of me. And I don't have that wall of separation between my own assets, my own personal business and dealings, and that of the corporation. I drive the corporate truck for non-corporate purposes. I use corporation property for my own personal benefit or gain or convenience. This commingling of assets will really show that you're not treating that corporation as a separate legal person. There should be separate bank accounts, and the corporate bank account should only pay for things for the corporation. My personal accounts shouldn't be used to pay corporate debts. Now, I can pay myself if I'm the sole shareholder, corporate money. There's no problem with that. But I've got to keep that wall of separation. I cannot commingle those assets. Another thing that courts will look at when considering piercing the corporate veil, holding the owners of the corporation personally liable for the debts and obligations of the corporation, is if I really just set up the corporation as a shell to begin with. And when I say a shell, I mean I've provided no capital to that corporation. The corporation has no money, never had any money, never really does anything. I've just used it as a shell to attempt to shield my own personal liability. So really, if the corporation itself is just a sham and I've never capitalized it, it's never had any money, it's never done any business, then that's another big factor that courts will look at in deciding whether or not to pierce the corporate veil. Okay, I don't want to get into a long laundry list of all the other factors that courts look at. I will add one more thing. I'm not keeping up with the corporate paperwork. In other words, there are requirements to have meetings, to have corporate resolutions, to keep up, and I don't want to get too much into that, but basically keep up with the paperwork of the corporation. If you fail to do that, and it ties in with treating it as a separate legal entity, but if you fail to keep up with the corporate paperwork, for lack of a better term, you risk having a court pierce the corporate veil. Okay, so basically what I want you guys to understand is not treating it as a separate person, commingling assets, risk losing your limited liability, and understand the terminology of piercing the corporate veil. Okay, let's move on to LLCs, or limited liability companies. There's a number of different varieties of these limited liability companies. We'll concentrate on the main one, which is LLCs. LLCs are pretty much the same with some important differences as corporations, in the sense that the owners of a limited liability company have limited liability. So the owners of a limited liability company are not personally responsible for the debts, obligations, and judgments of the LLC, just like a corporation. But we've talked about the problem of double taxation when it comes to corporations. So over the last several decades, all the states have provided for the creation of these limited liability companies. And the main reason for that is to keep that feature of corporations to have limited liability, to encourage investment and growth, But to try and ameliorate, for lack of a better term, the adverse tax consequences of a corporation. So, LLCs are taxed differently under some circumstances than corporations. What happens is if you are the owner of if you're the owner or one of the owners of an LLC, you get to elect how you're taxed, essentially. Now, I'm no accountant, I'm no tax expert, so I'm going to give you a basic rundown of how that works. When the owners of an LLC have an option, they can report the profits of the corporation on a separate tax return filed in the name of the LLC, because an LLC would be a separate legal entity just like a corporation, and you have to treat it as such, just like a corporation. So you have the option of filing taxes in the name of the LLC and basically paying what amounts to the corporate rate, or the owners of the LLC can use what we call flow-through taxation. So sometimes you hear these LLCs and similar forms of business organizations referred to as flow-through businesses. And when we say flow-through businesses, we mean that the profits of the LLC can be reported on the individual tax returns of the owners of the LLC. And the owners of an LLC are called members, not shareholders or stockholders. The owners of an LLC are called members, and you will definitely be asked a question on the test. What do we call the owners of an LLC? Members. You'll also be asked, what do we call the owners of a corporation? Shareholders or stockholders. So, the members of the LLC have the option to report their profits on their own individual tax returns. So basically what the owners of an LLC do are going to get together with their accountant and figure out what's the lower rate, to pay the corporate rate and just file an LLC return, or to have it flow through to their individual tax returns, and depending on what their rate is, perhaps a lower rate than the corporate rate. So this is the main advantage of LLCs, or one of the main advantages of LLCs, is you can elect to take that flow through taxation. And the rates on flow through have been reduced fairly dramatically here in the last 3 years. Excuse me a second. Sorry about that. And LLCs are all the rage now, essentially, as you see a ton of new businesses open up as LLCs for this reason, because you go to your accountant and you say, hey, I need some advice on setting up this business, or you go to the lawyer and say, I need some advice setting up this business. And 9 times out of 10, again, depending on your circumstances, maybe not 9 times out of 10, 7 out of 10 times, they're going to recommend an LLC. Also, the paperwork required for maintaining your LLC is significantly less onerous than that of a corporation. So really, one way to think of LLCs is it's corporation without some of the drawbacks or disadvantages of a corporation. Okay, again, you can elect to take that flow-through taxation, comparing your individual rate with that of the LLC rate. And that's something your accountant will help you with, but avoid that problem of double taxation. Again, LLC stands for Limited Liability Company. It provides the owners, who are called members, limited liability. Okay, now you can pierce the LLC veil under the same circumstances, essentially, as a corporation. And there's less common law in the area of LLCs as there are corporations. So that gives some lawyers some pause, but that's changing rapidly. I don't personally see that as a huge problem right now. I think most situations involving corporations will apply to LLCs in most cases. Okay, so let me see what else we need to get to here. Sorry, guys, I'm at the office today and I'm trying to do a bunch of different things at once and my computer is going nuts. Okay, I don't know why this is doing this. All right, I'm having some technical difficulties. All right, what I'll do is, let's see, fiduciary duty, Pierce Corporate Vale, LLC. Let me take just a minute to talk about how, and I know we've talked about this before, but corporations, LLCs, are creatures of state law. And so some states have laws which are perceived as being more beneficial to corporations than other states. So if you were to look at where a lot of these big publicly traded multinational, well, not multinational, big publicly traded corporations are headquartered, you'll see Delaware stands out as a state that has a lot of corporate headquarters where a lot of big corporations are actually incorporated, because Delaware has laws that are particularly favorable to the corporate entity. So if you want to take a look at, Google some of the biggest corporations there are, and see where they're headquartered, and see what their state of incorporation is. It has to do with taxes, corporate requirements, shareholders suits, things like that. And I'm certainly not an expert on any of that, but it is interesting to see which states have larger numbers of incorporations, particularly of large corporations, than do others. And Delaware stands out for sure. So if you're interested in any of that, you can conduct some of your own research. Okay, so I'm going to stop there, and what I'm going to do is I'll get your extra credit out to you either later this afternoon or tomorrow. You'll have at least a week or two to complete that. You don't have to do it, okay? It'll be worth 30 points, but you don't have to do it. If you've got A's on the previous two tests, you're probably in good shape. If you want to do it, that's great, but nobody is required to do it. Some of you need to do it. 30 points is a big deal. It can really help to raise your grade. So I'll get that out to you either today or tomorrow. That'll be it for lectures this week. Next week, we'll start reviewing for the final. You guys will have time to work on your extra credit if you want to. Again, if you have any questions or comments or concerns, feel free to give me a call, text me, shoot me an email. There's still probably 6 or 7 of you that never completed assignment number 3. I'll give you another 24 hours to get that done. So have them to me by noon on Friday, although I suspect the folks that haven't done that aren't watching the videos either. Hopefully I'm wrong. Most of you are watching the videos. I'm very pleased with how things have gone on short notice, and this is new for all of us, and it's really, in my opinion, no substitute for the classroom. But if you haven't done assignment number 3 and you want to get it done, just get it to me by tomorrow at noon. All right, guys, check your email often for that extra credit, and I'll talk to you soon. Thanks.